Welcome to a Question of Ethics conversation, a discussion of ethics, courts, and court administration. I think almost all of us are familiar with the classic decision-making model. Properly identify and analyze the problem, find alternative solutions, determine the pros and cons, select the best alternative, fund, staff, and implement that solution, obtain feedback on progress, and modify as needed. Now, one aspect of this model that does not receive adequate attention is problem analysis. Now, before anyone starts to think in their own mind that good problem analysis is a minor aspect of decision-making, may I remind you of some examples throughout history of the results of poorly analyzed problems. The Challenger space shuttle disaster and the O-ring failure. The financial crisis of 2008, brought on by mortgage-backed securities and collateralized debt obligations. The Treaty of Versailles, which ended World War I, but piled so much war debt onto Germany that their society could not recover. It caused bitter resentment, spawned the rise of Adolf Hitler, and brought on World War II. The stock market crash that occurred on Thursday, October 24th, 1929. To this day, there are people who will not invest in October or specifically on Thursdays because they think that that month and day had something to do with the timing of the crash. There are several highly effective business problem analysis models, each tailored to different types of challenges. Some of the most popular models are root cause analysis, which includes techniques such as the 5 whys and the Ishikawa Fishbone Diagram. SWOT analysis, which stands for strengths, weaknesses, opportunities, and threats. Gap analysis, which Robert Granzo spoke about in the June Question of Ethics conversation. This model identifies gaps between where an organization is and where it needs to be, then focuses on those areas of improvement. Here to talk about the pitfalls of problem analysis are Samantha Wallace, Deputy Trial Court Administrator for the Supreme Court in Coeur d'Alene, Idaho. Rick Pierce, Judicial Programs Administrator, Administrative Office of the Pennsylvania Courts. Stacy Werby, State Jury Coordinator for the Alaska Court System. And Credell Webb, Chief Diversity, Equity, and Inclusion Officer for the 1st Judicial District in Philadelphia, Pennsylvania. Thank you all for joining today's Question of Ethics conversation. Robert Granzo mentioned in his June 27th presentation that the first assurance a manager needs to have is political buy-in from the executive level. Rick, as a court administrator, what do you do if you have a serious problem, but you just can't get that political buy-in? Examples include addressing the needs of the homeless, preventing cyber threats, even procuring a new automated case management system to replace that dangerously out-of-date one that the court bought during the Nixon administration. When you get shut down, do you just move on to a new assignment? Do you keep trying to convince the powers that be? What is your approach?
Oh, and you put me on the spot, Peter. You go first. I think there are many ways to approach this. I think you could, it obviously depends. That's the big word, depends. Depends upon the subject, the issue at hand, and is it a priority? Is it a priority for you, or is it a priority for the people that you serve? If it's a priority for you, but not necessarily the people you serve, you need to differentiate there and then maybe drop it. But I think if it's a joint priority, if you see benefit, significant benefit, or significant detriment, if you do not move forward, then I think you still need to find a champion for the cause. I really strongly believe in that. And I think whether that's another jurist, or another executive, or maybe it's just another round of trying to convince that the person who is going to be the naysayer, which is your presiding judge or whomever. I don't like necessarily workarounds, so to speak, where you do an end around, particularly if it's the individual that's your boss. But at the same point in time, I do think there's a way of, if it's tactfully done, of having a conversation with others that may be at the equivalent level of them, whether it's another jurist or the county executive, and have the county executive come and speak with you and the president, the presiding judge. Maybe that, and that's been done, that was my experience quite a bit, although they generally approach me with their idea rather than the other way around when the presiding judge was shooting them down.
Well, I hesitate to use the word badgering, but sometimes just keep trying, keep at it. If maybe try and connect with whoever's standing in your way, or stopping the process from continuing, and see, maybe try and approach it from a different angle, try and get them to understand the importance of the issue. Because if you keep trying, I think most people will see, okay, maybe this is important. She's not letting it go.
Let me offer 2 examples where political buy-in may be difficult. One, where there is a potential threat to the court, but it is not imminent. For example, an old automated case management system that is vulnerable to cyber attacks. The response may be, there's been no attack so far, so let's see if we can just get through 1 more year on the old system. The second example that Robert Granzo discussed. The court needs to improve access for the disabled, but it has other priorities. The court is not immediately affected fiscally by choosing not to improve access, but public trust and confidence may be harmed. Are there different approaches to presenting these challenges to the powers that be?
I think you can also not underestimate the repackaging or restating your argument, perhaps bringing them around to a different point of view. Maybe they can't identify, with the people who have a disability. Perhaps it would be advantageous to take them through the day of someone who's trying to navigate your court and are having difficulties. If they, can't walk in the other person's shoes or can't see where the difficulties rise, maybe it's not a priority to them. So I don't think you can understate the importance of repackaging or repurposing what you're saying to them, so that maybe they can understand a little better if there's a little more context for them.
If it were a simple problem, someone probably would have already fixed it. Long-term problems are often long-term because someone or some group actually wants the situation to remain status quo. Credell, how do you describe a business problem with a political undercurrent and still keep your integrity? Do you name the forces opposed to solving the problem? What's your strategy?
Thank you for the question. And I think that's something that court professionals have to always consider, the politics of it all. But the answer, just like Rick said, it depends. You have to have an understanding of your organization, the organizational structure, but also the external factors, so you can't ignore it. That's definitely one thing you can't do. You can never ignore any political aspects, but focus on things like public trust and confidence and how our courts need to improve over time. All organizations have to find ways to improve their processes or things that they're doing. So maybe something was advantageous to somebody 20 years ago, and people don't find it advantageous now, but we're still doing it just out of, this is what we always done. So we have to examine who our leaders are and what relationship we have with them. So if you know, for example, that you have a leader that you can talk to about this problem and you have a decent relationship, I would lay it all out to that person and see where you go, see what they feel. Do they feel that this is something that can't be changed right now? Or do they feel like, this is something I never thought about. I didn't know that this was on your mind. So I think you should bring it to the attention of leadership if you're not sure. If you're 100% sure that there are some political implications and that there is some benefit to keeping this process around, but it's not something that we need, and okay, maybe I'm having sort of a moral issue with this, then I would say your approach needs to be a little different. See if there's another way that whoever this person is or whoever is in charge could still benefit without doing it that way, that political avenue. Is there another way that the person in charge could still have a benefit more ethically, if you will? And so I'm speaking in hypotheticals, but I think it's always worthwhile to bring these issues up. To just have it fester or to ignore it, in my mind, is not the best strategy, and it's not the best approach. And we have to think and we have to use innovation. There's a lot of new technology out right now. We spoke so much about AI during the conference. Is this a problem that AI can help with? I mean, we have to really think through the solutions that are available in 2024.
Let me offer an example. Self-service centers were initially controversial, and some courts still do not promote them. When they were just starting out, some segments of the bar, particularly those who worked in family law, thought self-service centers took business away from attorneys. Crudell, did that occur in Philadelphia, and how was it handled?
I think the matter is always about those self-service centers taking money away from attorneys, although I'm certain that some attorneys would think about it that way. There's also this idea of legal advice versus legal information. And is it that these self-service centers are providing legal advice? How far are they going? In my opinion, I think it's a little bit more of a trust issue. Are these self-service centers, are they going to provide strictly legal information, and are they going to cross that line? And so when I think about courts or leaders, that's something that's going to be on our minds, because if the court is saying we're going to put this self-service station here and something goes wrong, someone loses a case, I think there could be some liability with that. So there are a number of considerations to those. Now, on the other side, we have to weigh that out with, when you think about like dimensions of diversity, socioeconomic factors. There are some self-represented individuals who don't make enough money to hire an attorney, but they may make too much money and they can't go to, let's say, community legal services. So having some sort of a station or a kiosk that could just give them that extra nudge would be of extreme benefit. So there's no clear-cut answer here. I think it's going to be a balancing act.
A bad organizational joke is that one of our most common forms of exercise is jumping to conclusions. How do we proceed if a solution has already been laid out for you? For example, a judge is very concerned about the plight of veterans. He asks you to analyze the problem of veterans in need for presentation to the bench and to your funding body. During your analysis, you reach the conclusion that although the plight of veterans is real, the homeless problem in your community is much more serious. Stacy, how do you write up your analysis?
Well, I think that it's important to put it into context. So if the problem with people who are homeless is larger than maybe the veterans population, maybe that could be a note along with it. If this funding is specifically though for veterans, I don't think that would be of benefit. But if you're trying to benefit the community as a whole, I think it would be important to include the other disenfranchised populations in your area. So it would be, in my mind, important to include it depending on what the funding was. If you're getting your funding specifically for veterans from a veterans group, then I don't think it would be very helpful. But it might be a good note to include, to the judge, so that they have that reference for further funding decisions.
I have perceived that problem analysis is not an area given much emphasis. Samantha, am I wrong? Should NACM provide more training in problem analysis?
I would say yes. I think it can absolutely be beneficial. I think just this meeting has been beneficial, even just to me thinking about these questions and the answers to them. I mean, of course, everything is complicated and nothing can ever just be simple, in the court system. But I think when you gather together court professionals from all across the US, including, Puerto Rico, the Virgin Islands, and I think it's so incredibly important to hear from other people. And so if NACM were to present these questions, maybe the answer would be simple. Maybe another court, figured out how to do it, and it could be implemented in your own home courts.
Mm-hmm.
Sure. I think that relationships are really at the core here. What we're talking about, though, yes, you can have some limited success regarding your negotiation skills to have a particular project done or address it in some manner that it's going to be beneficial to have a priority. But if you don't have a relationship established, your success is going to be very limited. Whereas conversely, if you have a relationship established even the difficult conversations become a heck of a lot easier to have, and they can actually take place. Whereas if you don't have a relationship with whomever it is that you're doing this negotiation with, I think that becomes a real challenge because the trust is just not there.
Fostering these relationships is extremely important, but is there also a concern we should be aware of? For example, there is a term called preemptive avoidance, where a person decides not to bring up a topic in the first place because they know it will provoke a negative reaction by the group. Is this a concern in relationship building?
Well, it is. I think it is a concern, and you have to be courageous when you're every party that's going to be involved in this decision making is going to have some level of courage to move forward, to come to a consensus or an agreement that this may be something that is not necessarily desired but needed. But at the same point in time, that's why we're paid the big bucks, except we're just not paid the big bucks. But that's the point of this, being in this position is, you're going to have these difficult conversations, and you've got to rise up to that, have that level of courage to go beyond what you're stating there, Peter.
Mm-hmm. Okay.
I agree. Oh, go ahead, Credo. Go ahead.
I agree with that point, Rick, and I just wanted to add that having a good relationship means you are the type of person that can bring forth an opposing view. I don't think it means that you hold off and just say yes to this person all the time, because if there is something that person hasn't considered and you have that information and you're not willing to share, I wouldn't really say that was having a good relationship. What I will say is this: I'm okay with holding something off if this is not the right time. Like maybe right now, this leader is dealing with X, Y, and Z, and over the next 20 days, we shouldn't also add this to their plate. That's okay. But if you decide never to add it because people don't want to talk about that, I do find that to be problematic.
Oh, I was just going to say that I also agree. I think ignoring the problem never makes it go away. I mean, Credell kind of touched on this on his earlier answer. It just makes the problem fester. And then eventually it will come to a head where you have to deal with it. And I think if you can have conversations in a safe space, then I think it's really helpful. I will piggyback on your question to me earlier about NACM doing one of these topics. And I think for me personally, I have gotten more out of the plenary sessions where it's more conversational and sort of like, we're just having a conversation versus just a strict, kind of lecture.
Yeah.
And so if NACM were to present this, I think this is a good platform or a good way of doing it.
Thank you all for participating, and we'll see you on the next episode of A Question of Ethics Conversation. Thanks for joining us today. The Question of Ethics Conversation is a regular segment on ethics, courts, and court administration. Today's episode will be available on our website, in the Court Manager Journal, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on X, formerly known as Twitter. Become part of the conversation. Join us live when we hold the Question of Ethics Conversation. Episodes are held immediately following the monthly NACM Ethics Subcommittee meeting on the fourth Thursday of the month. Check the NACM Committee webpage for the schedule and Zoom link. If you have questions, comments, or ideas for future conversations, email us. Our address is ethics@nacmnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search the entire episode to find it? The Additional Resources section on the webpage has a question time marker sheet. Find the discussion question on the sheet, and next to it is the time that question was asked. You can quickly fast forward to that time and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the hosts and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.